Good morning, Ms. Mayor. Good morning, everybody.
Good morning, Chair.
Yes. Before we start, I just need to make one announcement, or two, probably one. The next appearance before the Commission of the President of the Republic, President Ramaphosa, will be on the 31st of May and on the 1st of June. Those are the dates that I have determined, so I announce them so that the public knows. He will appear in his capacity as the President of the country, but as everybody will remember, there will still be some issues that he will need to deal with, which he could not be dealt with when he appeared before the Commission in his capacity as President of the ANC. So he will deal with those issues, and then he will give his evidence and be questioned in his capacity as President of the country. I also wish to indicate that it is the intention of the Commission that his appearance will, for all intents and purposes, subject to one or two qualifications, be the last appearance, or will mark the last witness to give oral evidence before the Commission next week. The Commission is trying its best to wrap up all oral evidence. I said that will be subject to one or two qualifications. I will deal with those qualifications at some stage next week after he has completed his evidence. So I will do so either the following day or within 2 days or so after he has given his evidence. The Commission will still or is mindful of the fact that there are some applications for leave to cross-examine that have not been disposed of as yet, and these will be given due consideration, and where the interests of the integrity of the work of the Commission and the interests of all concerned indicate that some exceptions must be made and some witness must still be called that will be looked at. But on the whole, the Commission wishes to wrap up its oral evidence because by end of his evidence, it will have covered all the important evidence relating to the matters that were included in the Public Protector's report that gave rise to this commission. Everybody will recall that some time ago I indicated that in order for the commission to be able to complete its work, within the time that we are looking at, or even last year, we would focus on what I said were public protector issues. That is, those issues that the public protector had included in her report as issues that this commission should investigate, as opposed to other issues that fall within the terms of reference of the commission but fall outside of those public protector issues. So the issue of applications for leave to cross-examine that have not been disposed of is receiving attention, and where it is necessary to accommodate specific cases, proper consideration will be given to that. But for all intents and purposes, the Commission is looking at wrapping up the hearing of oral evidence next week. There may be a few individuals that, in my discretion, I might decide might be required to either finish affidavits later in June or appear briefly to deal with certain matters where, in my view, it's important for the work of the Commission that those individuals be covered. So I thought that I must mention this. And of course, I must indicate that we had initially contemplated that the hearing of oral evidence would be completed by end of March. That is why in the application that I made to the High Court for the extension of the term of the Commission from the end of March to the end of June, I had indicated that the months of April, May, and June would be used for the preparation of the report. That assessment had been made in good faith, and everyone knows how the Commission has been working extremely hard since the second half of last year, holding double sessions, day sessions, and evening sessions to try and finish its work. But we did not succeed in having oral evidence completed by end of March, despite our best efforts. And everyone knows that if we had ended the hearing of oral evidence by end of March, there is very important evidence that has been led in April and May, which would have been left out, which the nation needed to hear. And that includes some evidence relating to the State Security Agency. But it also includes evidence by some of the high-ranking officials of the SOEs, in respect of whom there have been serious allegations of corruption and state capture. So it was important that those high-ranking officials, that time be given, be allocated for them to complete their evidence. But by the end of May, by the time the President completes his evidence, we will have finalized the oral evidence relating to senior executives and board members of various SOEs that have been alleged to have been looted as part of state capture. So I thought it's necessary that I explain that. It will be necessary to apply to the High Court for a limited extension, but that will now be for the preparation of the report, because during the 2 months, April and May, although a lot of work in regard to the analysis and of evidence has been going on behind the scenes, that will not enable us to have the report by end of June. So it will be necessary to apply for a very limited extension for the purpose of the preparation of the report. But as I say, a lot of work has been going on behind the scenes aimed at the facilitation of the preparation of the report. That is the end of the announcement. Okay, Ms. Hofmeyer.
Thank you, Chair.
Thank you.
Chair, we convened today for the hearing in order to receive further evidence from Ms. Duduzile Myeni. You'll recall, Chair, that we ended her last evidence on Friday the 6th of November with 2 outstanding remaining matters. The first of those was the need for her to be questioned by my learned friend, Mr. Seleka, who is working on the Eskom streams evidence, and that was particularly in relation to Ms. Myeni's alleged involvement in certain meetings in 2015 related to the suspension of Eskom executives. We had run out of time in the 3 days that had been scheduled for her evidence, and so that topic for questioning remained to stand over for another date. Chair, the second aspect that remained standing over at the conclusion of Ms. Myeni's evidence on the last occasion was the need for consideration to be given to her invocation of the privilege against self-incrimination throughout the course of her 3 days of evidence. And Chair, I would just like, with your leave, to remind the public and everyone here today precisely how you'd ended the evidence of Ms. Myeni on this particular point. And Chair, this is a reference to the transcript of the 6th of November 2020's hearing. It commences at page 258 from line 21. Chair, what you said there, and I quote, is, "The other point is the one that I mentioned earlier, namely that there is no time now, and it's not convenient really, to look at Ms. Myeni's entire evidence and see which questions she may have justifiably invoked the privilege not to incriminate herself, and which ones, in respect of which ones, she might not have done so justifiably or correctly." Chair, you then requested that the legal team in particular consider the transcript of the evidence over those 3 days. You indicated that you would do so as well. And then we would revisit the question of whether the privilege had been justifiably invoked. What happened after the conclusion of the evidence on the 6th of November is that the legal team of the Commission did that exercise. We considered the transcript closely. We went back to the references that were actually made throughout her evidence when, on the basis of the reasons she had given for not answering questions, I made the submission that the privilege was being abused. We went back to those. We distilled what we said were the questions that had not been legitimately refused to be answered on the basis of an invocation of the privilege. And we sent certain legal submissions to Ms. Myeni at the beginning of April this year, setting out the position of the legal team, setting out the fact, cataloguing through the transcript where we said that the privilege had been abused and what submissions we would make to this commission in the light of that alleged and submitted abuse. Ms. Myeni was offered an opportunity to respond to those submissions, but none came in. None came in until about the middle of May, and in the middle of May, Chair, you directed that she should return to the Commission, both to deal with this outstanding issue and the ESCOM evidence. And then, through a change of attorneys, about which we were notified only last Monday, arrangements were made to provide Ms. Myeni again with the submissions from the legal team. And on Friday last week, we received a response to those submissions from her current attorneys. Now, in the course of those submissions to the Commission, Ms. Myeni concluded through her attorney her submissions with a request. And it was a request in the following terms. Let me just be clear. My learned friend and I may need to get into the debate of the merits of the submissions, but just in summary, the submissions deny that Ms. Myeni abused the privilege, deal with certain legal principles, make some comments about retrospectivity of the Constitutional Court's decision in January. We'll get into that if we need to. But then it concludes in the penultimate paragraph with the following. I think it's supposed to be therefore request that the Commission stay execution of the summons for our client to appear on the 25th of May 2021, as we need to first have the benefit of your responses to all the above before advising our client accordingly. Now, that is a reference to the summons that was issued by this Commission in terms of the Commissions Act. Chair, you no doubt will be well aware, and I'm sure the public by now will be well aware, that it is a criminal offence not to appear when there has been service of summons without sufficient cause. Ms. Myeni has not appeared today. She indicates recognition of receipt of the summons. It was a considerable effort for the Commission to ensure that summons was effected, because repeated efforts to engage Ms. Myeni, both by the Sheriff and the Commission, came to naught, but eventually there was an affixing of the summons at her property, which constitutes good service under the Commissions Act, read with the rules of court. But I don't understand there to be any debate that that summons was received. It required Ms. Myeni to be present today. She is not present, and I understand from my learned friend that he will now seek to move a postponement application. So with your leave, Chair, I propose that we allow my learned friend to move it. I've indicated to my learned friend and to you, Chair, in Chambers, that that postponement application will be opposed by the legal team of the Commission. And so with your leave, if I may be permitted to ask my learned friend to move the application.
Yes. Mr. Buthelezi, you may. Somebody must just sanitize if you are going to use the podium.
Good morning, Chair.
Good morning, Mr. Buthelezi.
Thank you, Chair. As my learned friend has prefaced, Chair, I appear before you this morning to request a postponement of the appearance of Ms. Myeni. And the reasons behind that, Chair, I'm at first at pains to stress that it's not an indication of reluctance on her part, and ultimately the issue can be reduced to a breakdown in communication. Now, Chair, where we start with this issue.
Of course, the first thing is for you to indicate whether you confirm that she is not here despite having been served with the summons that required her to be here this morning.
That much is true, Chair, I confirm.
Yes.
Sorry, Chair.
And is the reason why she's not here the same reason why you asked for a postponement? Because in terms of sequence, I should first be satisfied that this is not defiance, because the question may arise as to why should I even hear an application by her for a postponement when she is in defiance of the summons and of this commission? Because one would expect that if she has a legitimate reason for a postponement, she would appear and say, I'm here in compliance with the summons, but I am applying for a postponement for the following reason.
Indeed, so, Chair.
So you can deal with that.
In dealing with that, I'll go to the paragraph that Ms. Hofmeyer quoted
Yes.
from the letter that was delivered on Friday, 21st.
Yes.
Which reads as follows. We therefore request that the Commission stay execution of the summons for our client to appear on 25 May 2021, as we need to first have a benefit of your responses to all the above before advising our client accordingly. Now, Chair, I don't know whether it's fair to the attorney, but the Commission did respond around after 9 p.m. on Friday evening. And I've shown this to Ms. Hofmeyer. The attorney sent me the response at 10 p.m. last night, saying he only saw this email at 4 p.m. Now, that's not for the Commission to rectify, or it's no fault of the Commission. The Commission did respond. What subsequently happened with the attorney not picking up or not communicating to the client was under the bona fide impression that the request for a stay of execution of the summons, pending the response from the Commission, would have then been accepted, or no response had come through. So, to deal with your point of defiance, Chair, I point out to you that first, it was requested of the Commission to say, we have a certain view with regards to the correspondence that you sent. Now, at the start of that letter, it starts as follows. It says, we place ourselves as attorneys of record in the matter concerning Ms. Myeni, as she had ceased being represented by Mabuza attorneys since early April. Further evidence of that, Chair, is confirmed by the fact that how this correspondence now for this appearance got to Ms. Myeni was through the Commission contacting her directly after not receiving any responses from Mabuza attorneys. And the people at the Commission were aware that they had to then contact her directly, and she then had to instruct new attorneys to pursue the matter. So prior to being contacted by the Commission, she was not aware. And the letter does say, as a result of the aforesaid, Ms. Myeni did not receive correspondence of 1 April mentioned in your letter and has only come to know of the Commission's attempts to reach her in correspondence that was sent directly to her. And it is in that direct correspondence, Chair, that she took the steps and then appointed a new attorney. Through an unfortunate circumstance, as I will illustrate, as I've stated, Chair, she and the attorney were under the impression that the Commission had not responded. And
in which case they should have taken the attitude that the summons stands and therefore she should appear.
Indeed so, Chair. Correctly so. And I advised accordingly yesterday, and I said, look, regardless of a non-response, you need to take the necessary steps to make sure that we do get here. And it was only then that I think a concerted effort for the email to be traced or somehow found, maybe it could have been lost in a heap of emails from an unknown address, that it was actually discovered that the Commission did respond. But due to time constraints and as I showed Ms. Hofmeyer that he says he only picked up the email at 4 p.m. yesterday. And given that Ms. Myeni is not stationed in Gauteng, she was then of the view that, look, can you approach the commission on my behalf and request a solution to say, how do we facilitate their appearance? In other words, is there still a prospect for this to be heard online or to be deferred to another date, either later in the week or early next week, or whatever workable solutions? But the one thing that is absent from all of this is a reluctance to appear, Chair. So it may inconvenience the commission, and we apologize, Chair, and it may cause consternation, but in as far as it seeks to imply that there's defiance of the Chair's commission, summons, I submit, Chair, that there is none. There's no such intention, and I think we have indicated by the last paragraph that says we request a stay of execution. In other words, we didn't take a point that says we'll just won't appear because we've written you a letter. And in concluding that letter, we submit that pending your response so that we know how to advise clients accordingly. So in as far as intent not to comply, I think that test is not met, to say, because I think there was intent, and in as much as we may want to impute that defiance to the client, I think there's some level of evidence that removes culpa from her or maliciousness to that extent. Now, Ms. Hofmeyer had raised certain points, Chair, and I need to take these points because she glossed over them. The first one is that client was advised about the invocation of the privilege against self-incrimination. And we took the view that the test set by the Concord to the effect that would this privilege be applicable in criminal proceedings? Would this be a privilege that you would be able to invoke in criminal proceedings, yes or no? And I think that's the test. And we relied on the submission that we have already, in all matters referred to SAA, been referred to criminal investigation. And we say that the prospect then of self-incrimination is triggered by a court order. It's not in the abstract. Apart from it not being in the abstract, we also read the Concord decision.
I think let's separate the issues.
Yes, Chair.
Because that belongs to another phase.
Yes, Chair.
Yeah. Let's deal with the phase where we are. Is the position that if I direct that your client gives her evidence via Zoom or whatever link, she is ready to comply with it?
Indeed, Chair. The only issue would then become a matter of organizing it for when. But
well, I'm talking about
today.
Today. I'm not talking about another day. I'm talking about today.
I'd have to take direct instructions on that point, Chair. Because my discussion with the attorney last night, we didn't have a clear indication of the state of readiness for client to testify in terms of one receiving those files, whether she'd be able to access whatever documents that the commission would need her to work through. Yeah. That's the only logistical challenge that there may be, Chair.
Yeah, because if from her side she did not mean to not to cooperate with the commission and didn't mean to defy, one could expect that because she knew that the summons required her to be here, she may be available if I approve that she be connected via via Zoom or whatever link so that we can proceed, because otherwise the time might be lost. So maybe I should adjourn for you to take instructions on that, because depending on what the answer is, it may be that we might not need to be detained too long on certain issues. Of course, if we went that route, the question of her non-appearance here would be one thing, but if she is available and arrangements are made and we are able to continue, that might be another issue. So, but if the position is that she is not available, then one must take it from there. Ms. Hofmeyer, what do you think about that suggestion? I know he hasn't finished, I think. What do you think about a short adjournment for Mr. Mckay to get instructions? Yeah, I think...
Thank you so much. I feel as though I'm in some sort of studio. I do apologize.
Yeah.
Chair, the legal team's position is that such an arrangement is unlikely to work. And the reason I say that, Chair, is that for the better part of 10 days, we have been seeking to engage with Ms. Myeni directly to ensure that she has the bundles that she requires in order to give evidence today. There are repeated screen grabs of every effort multiple members of this commission have made to contact her, to say there is a link that you need to download in order to get the documents. There has not been a single response from Ms. Myeni to those efforts. So it is impossible, I submit, for Ms. Myeni's evidence today to take place via Zoom, because she has not a single document that would be required for this evidence to be conducted. The assumption, because she made no effort to respond to one of those messages, was that she would understand her legal obligations, appear today, and then would be given hard copies of the very bundles that we had made efforts for the greater part of 10 days to give her access to. So, Chair, my submission is that a Zoom hearing today will not work. She does not have the documents that she needs in order for evidence to be conducted. And as my learned friend Mr. Seleka will no doubt inform you, he'd asked me to address this at the beginning today. The efforts of the ESCOM team to have her receive documents from them start as far back as August of last year. There has never been any response from Ms. Myeni to the efforts to get her the statement from Mr. Linnell before Parliament so that she could consider it, and how it differs from the statement that she gave Parliament in the ESCOM inquiry about what happened at those meetings. Chair, at no point has there been any effort on the part of Ms. Myeni just to receive the documents from the Commission so that this evidence could take place meaningfully today. So, Chair, my submission is I'd like to respond to my learned friend. I'd like to deal with the question of defiance, because a Zoom hearing is not going to work on the basis of the facts as I know them.
That she doesn't have the documents.
No.
Mr. Mchelezi, what do you say to that?
No, my only point was to say, Chair, if we are to consider an online hearing today, the issue would arise in terms of clients accessing documents. So in as much as it may not be possible today, I don't rule out the possibility of it being possible maybe in the second half of today after lunch, if the link is made available and means are made to expedite that even if we adjourn by 2 hours, we could get some work done. If there are links and there's somebody there to assist her with the technology of accessing the documents, we could make a bit of progress here versus throwing the entire day away.
I know that the matter relating to ESCOM is a narrow one, the ESCOM matter. Well, let's do this. Let me adjourn now for something like 10 minutes before Ms. Hofmeyer can respond, for you to take instructions of what is possible and what is not possible from her side and from your side as a legal team. And then when we come back, you report to me what is possible and what's not possible.
Thank you.
And then I'll hear Ms. Hofmeyer, and then we take it from there.
Thank you, Chair.
But do make it quite clear that her non-appearance this morning here is viewed in a very serious light.
Thank you, Chair.
We adjourn. Yes, Ms. Hoffman.
Oh, apologies. Just my page has dropped. I had a conversation with my learned friend over the break. He has managed to make contact with Ms. Myeni. Ms. Myeni was on her way to a family engagement in Port Shepstone. So she's now making efforts to turn around, but there's some uncertainty as to when she'll get back and if to the attorney's office and what can be done. So where I've left things with my learned friend is I wanted to just update you that that's where we are. Ms. Myeni was on her way to a family engagement, and she's now turning around because she received a call from my learned friend, Mr. Buthelezi, but there's uncertainty. So I suggested to Mr. Buthelezi I'd continue to make my submissions in response so we don't lose more time, and then maybe we can get an update a bit later.
Okay, all right. Please do.
Thank you.
Well, before you do that, I think I had a question for Mr. Buthelezi. Maybe if his mic works, he can respond from where he is.
Thank you, Chair.
It relates to the other phase that you were touching on, and I said, let's leave that for later. Is your position that as far as the invocation of the privilege against self-incrimination, is your position that, one, it was justifiably or properly invoked in regard to every question that has been raised by the Commission's legal team in their written submissions? One, two, or is the position that you still want to, you or your client want to provide grounds of justification for invoking it? Or is the position that the reference to the High Court decision referring some matter to the NPA for investigation is the justification? What is the position?
Thank you, Chair. To answer you directly, the justification is the judgment of the Pretoria High Court. We submit that the privilege has been properly exercised. Now, in the response that we gave to the Commission last week, we had received a set of questions that we were asked to respond to. And we felt that those questions in the main fell under the ambit of the set of questions where we would invoke the privilege anyway, or we had already invoked the privilege. And our interpretation thereafter, we say that even if we are wrong in this interpretation of the Concord judgment, in as far as the Commission is concerned, we were of the view that the Constitutional Court has not said the judgment finds retrospective applicability. Now, Ms. Hofmeyer raised the point earlier to say you had created a proviso that said that the Commission would go back and review the evidence in its entirety. But if we look at the entirety of the questions that subsequently followed, many of them were a repeat of the questions where the privilege had been invoked, and many of the questions covered pretty much the same areas where we had advised that these pass the test of where the privilege can be invoked.
Yeah, okay, right. Ms. Hofmeyer.
Thank you, Chair. Chair, you commenced with a question when my learned friend began moving the postponement application. And with respect, I want to submit it was the right question. We may not even be in the world of a postponement if Ms. Myeni is in defiance of a summons served by this Commission. Chair, my submissions this morning to you will be that Ms. Myeni is indeed in defiance of a summons, and that is a criminal offence. Chair, the reasons I say so are the following. First, there is no affidavit before this commission from Ms. Myeni. It is trite that any explanation pursuant to a request for a postponement must be done on oath. It must be evidence. We have not even been favoured with an affidavit from Ms. Myeni explaining her position. That's the first point. The second point is that the only explanation we have been given from the bar by my learned friend is that when, through her attorneys, she asked on Friday for a summons to be stayed, and she did not receive a response, she thought she could not come today. Chair, that defies, with respect, even logic, because when the summons is in place and the compulsion power of this commission has been exercised, and you motivate for it to be stayed, and according to evidence from the bar, you receive no response, it is not sufficient cause for you then just simply not to appear. The assumption must be the summons stands. There has to be another exercise, Chair, by you. You are the functionary empowered to issue summons to compel evidence before this commission. On the version we got from the bar today, Ms. Myeni knew nothing of a further decision having been made on your part, which would be the only basis for her not to appear. Chair, we then heard, this is the third reason I say that she has committed a criminal offence, from her counsel this morning, from the bar, that yesterday afternoon he advised her that she must be present today. We have no affidavit. We have an approach to a request for a stay that makes no sense at its lowest. And we have, from my learned friend, an indication that legal advice was given to her to be present, and she is not present.
Sorry, Chair. I object to that submission, Chair. I'm objecting to the last submission by Ms. Hofmeyer.
I think I'll give you a chance when she's done to respond.
Thank you, Chair.
Yeah.
And then the fourth indicator is, again, that we've been told Ms. Myeni this morning was en route to a family engagement. Chair, there is no respect in which the summons that this commission issued for her to appear today has been taken seriously by Ms. Myeni. If it is so that she is on her way, or was on her way, until she received the call from my learned friend to a family engagement in Port Shepstone. Chair, this is not, unfortunately...
Of course, in addition to the point you make, or in substantiation of it, is when you instruct your legal team to apply for a postponement of your appearance before the commission or before a court, when there is a summons. One, you should be there yourself, unless the reason for the application for a postponement is one that prevents you from being there. For example, if you are sick, okay? But if you are not sick, and we have not been told she's sick, if you are not sick, even if you thought that it's not necessary for you to be there at the time your counsel makes the application, you needed to say, what if my application is refused? Because in that case, I must be there. if she is on her way to a family meeting, that doesn't reflect the mind of somebody who genuinely sought a postponement, because if you genuinely seek a postponement, you must leave room for the possibility that your application may be refused, in which case you'll be required to be there.
Indeed, Chair. If not, you've taken the postponement for yourself. As my learned friend, Mr. Seleka, said to me over the lunch break, over the adjournment. Chair, there's a further matter.
So it means in that situation, you are not waiting for a decision on your postponement application. And
You've
the question
decided it.
arises, in your own mind, what do you intend is going to happen if your application is dismissed? Do you have in mind that you would still comply, or do you have in mind that you won't comply anyway? So therefore, it doesn't matter what the decision is, because you don't intend complying if your postponement application is refused.
Chair, it is our submission that that is the quintessential example of a person who does not appear without cause. Ms. Myeni has not appeared today, and there is no sufficient cause for that non-appearance other than the explanation that we've been given, which amounts to nothing more than a postponement having been taken by Ms. Myeni. And Chair, just on that point, we're dealing with defiance. We're not dealing with postponements. But I may just give you the language of the Constitutional Court in the case of Psychological Society versus Pelani. That was a case dealing with postponement, and I'm reading from paragraph 30 of the judgments. Postponements are not merely for the taking. Well, today, the postponement has been taken. Chair, there's a further matter that I do believe I need to address in the context of the defiance question. And that is an issue that goes back to the approach that Ms. Myeni has taken generally to accountability for matters that this commission is concerned with. And the reason I go there, Chair, is that the very matter that she was going to be coming today to deal with, the outstanding matter of Eskom, was a matter that was, of course, investigated by an inquiry by the Portfolio Committee of Public Enterprises in Parliament. And there were efforts there, Chair, that were made to have Ms. Myeni come and account to the Portfolio Committee. And there is a commonality between what happened there and what has happened today, which is the final submission on which I say there can be no doubt that Ms. Myeni's conduct today is not about a genuine attempt to make arrangements to be accountable and give a version. It is part of a pattern of a steadfast resistance to be accountable to those who require answers about what has happened within our country. And Chair, for that purpose, I have a short bundle of documents that I would just like to hand in. Chair, we've just numbered them. It wasn't certain whether I'd need to make reference to them today, so I'm going to propose that we enter them as Exhibit 30, DD 34C. If I could just beg leave to hand up through your registrar, and then just make available a copy to my learned friend.
Yes.
Chair, if we can enter this document as Exhibit DD 34C. It will then just come next in the bundle of documents related to Ms. Myeni's evidence.
Exhibit DD
34C for CAT.
34C.
And it runs from page 1 to 12.
Should we... Or the second document is a parliamentary summons.
Correct.
And then there's... should we make them, say, Roman figure 1, Roman figure 2, Roman
Yes,
figure 3?
we can certainly do that. And then I'll produce an index just that will identify each of them, Chair, because as you've already seen, they are different documents, but they
Yes.
relate to the theme
Yes.
of the efforts that Parliament made to summons Ms. Myeni to the inquiry previously.
So the top one, let us make it Exhibit DD 34C, Roman figure 1.
Yes.
And then the next one will be Roman figure, will be Exhibit DD 34C, Roman figure 2.
As we go through it, Chair, I will
Yes.
give the relevant necessary Roman numerals.
Yes. Yes.
Chair, just to locate us, if we may,
Yes.
what happened was that the Public Enterprises Inquiry into ESCOM took place towards the end of 2017 and early 2018. And there had been an effort originally around February
Yes.
where Ms. Myeni had been invited to attend the...
I seem to remember that she didn't speak at some stage.
beg your pardon, Chair?
I seem to remember that she didn't appear in Parliament when she was required to appear.
Yes, that's what I want to take, Chair, with your leave,
Yes.
you through today.
Yes.
You see, there was originally just an invitation for her to attend. And that was an invitation for her to attend on the 28th of February 2018. She didn't attend.
Yes.
She gave an explanation for having done so. I think she communicated on the morning of that day with the relevant functionaries. And thereafter, she provided a statement.
Yes.
A few days later, on the 5th of March 2018. But Parliament and the Portfolio Committee, well, let's be clear, the Portfolio Committee on Public Enterprises did not, in its wisdom, regard the statement as sufficient and therefore decided that they would exercise their summonsing power, which is a power that they have under Section 14 of the Powers, Privileges and Immunities Act of Parliament. And so you'll see the document at Roman 2 of Bundle DD 34C is the summons that
Yes.
was issued.
So she had to be summoned even in Parliament.
Even in Parliament, indeed, and it required her attendance on the 11th of April 2018. Now, if you go back a page to the first page of this document, Roman 1, DD 34C1, that's the return of service that was obtained from the sheriff when he endeavoured to effect service. And what you'll see there is that the sheriff says, I certify that on the 4th of April 2018 at 5:55 in the evening, I served the summons to appear before the National Assembly Portfolio Committee on Public Enterprises on the defendant, Ms. Duduzile Myeni, at her place of residence, 102 Kolssterkring Meersenseer, Richards Bay. I just pause there, that's the same address that we used for service. By affixing a true copy of the process to which appears to be the main outer gate. And then a reason for affixing is given. Mr. Eric, security guard at the given address, refused to accept service of the said document, advising that the defendant was not there. All the house lights were on, but he refused to advise me who is in the house. So this is what came back to Parliament, Chair. And in the aviation team's investigations over the last 2 years, one of the topics that we thought required further exploration was, well, what happened? There was a summons, it was served, but Ms. Myeni never appeared before the Portfolio Committee. And so we engaged with Parliament and the Portfolio Committee in our investigations. It never became pertinent before today to refer to this, because on the last occasion, albeit that we found out the day before that we had to make Zoom arrangements, Ms. Myeni did appear. But today, the significance of this prior attempt by a body seeking accountability to have Ms. Myeni come before it, in my submission, does become relevant. So, they get the return of service, but Ms. Myeni does not appear on the 11th of April 2018 as required. So what happens thereafter, if you go to page 4, Chair, which will be Roman 3 of DD 34C, is a decision is taken by the Chairperson of the Portfolio Committee on Public Enterprises that is referred to in a letter to the Speaker of the National Assembly, Ms. Mbete. What it says, in essence, is that on the 17th of April 2018, so that's about 6 days after the scheduled appearance, the Portfolio Committee on Public Enterprises met to receive a report on the service of summons on Mrs. Gupta, Mr. Duduzile Myeni, and Ms. Duduzile Myeni. Copies are attached. The committee was informed that the sheriff could not serve the respective summonses on the Mrs. Gupta and Mr. Duduzile Myeni, as no one was resident at their last known addresses. And then they ask for they're going to seek legal advice about alternative methods of serving summons. But at 3, the following is recorded. The sheriff served the summons on Ms. Duduzile Myeni at her place of residence. However, Ms. Myeni failed to appear before the committee. The committee resolved that criminal charges must be pursued against Ms. Myeni in terms of the Powers, Privileges and Immunities of Parliament Act for her failure to honour the summons. Chair, that section is equivalent to the section in the Commissions Act. In the Powers and Privileges Act, it's section 17, and it uses also this without sufficient cause qualification to the non-appearance. But it is a criminal offence under that act, and this is the Portfolio Committee's chairperson advising the Speaker of Parliament that the committee has resolved that criminal charges must be pursued. Over the page is the response that came from the Speaker, Ms. Mbete. Chair, there's unfortunately a blank page that's been inserted between 5, so 6 actually doesn't need to be there, but this will be Roman numeral 4 of DD 34C. Chair, the essence of what Ms. Mbete details in this letter is that, and I'm in the second paragraph, after she received the correspondence from the chairperson of the Portfolio Committee, she requested a legal opinion on the question of whether authority would be competent, which authority would be competent to lay a complaint against a person who fails to comply. And she says that the advice found that the Act does not direct that any specific person must lay a complaint, and went on to suggest that the chairperson of the committee should do so. But notwithstanding the above, Ms. Mbete goes on to say, I should indicate that unless explicitly empowered by statute or the rules, committees do not act independently of the Assembly. Instead, the rules and practices prescribe that committees must report, and in cases that necessitate that remedial or other action be taken, may make appropriate recommendations to the House, which can then take informed decisions. And so she concludes by saying, as Speaker, I then convey or implement those decisions as the case may be, and based on the circumstances, I'm of the view that the Commission must, and then if we go over to 7, the committee must detail the aforementioned matter in a report to the House with a recommendation, which can then be duly acted upon. And then she deals with other witnesses. Chair, the Commission sought to understand what happened after this, right? May 2018, the Speaker is advising the committee that it's the National Assembly that must make a decision on this matter, and that there needs to be a report and a recommendation placed before it. And so we followed up at what is page 8 there. It will be document Roman numeral 5, about this very point. And we asked for Parliament to provide us with a copy of that report or recommendation that was made to explain, if one wasn't, why it wasn't. And unfortunately, the response that came back, which is at page 11, which will be document Roman numeral 6, is that the Commission had everything that Parliament had, and that was in its custody. And so the conclusion that certainly we submit can be drawn from this is that no further steps were taken in respect of a recommendation or a report being placed before Parliament.
So does it appear like Ms. Mbete, as the Speaker of the National Assembly, didn't lay a complaint?
Yes. We asked specifically for any complaint that was ever laid as well in our request to Parliament. So no complaint was laid. There was a request for a report and a recommendation on next steps to be placed before Parliament. No such thing happened. And the consequence of all of that is that Ms. Myeni was previously summoned to appear before Parliament. The Committee of Public Enterprises took the view that her failure to attend constituted a criminal offence and a charge should be laid. And nothing has become of that. Chair, Ms. Myeni attended here, yes, on the 4th of November last year. But as our submissions on the invocation of the privilege show, it is the submission of the legal team that she did so effectively with an intention to claim a right to silence, not meaningfully to engage with the questions that the Commission had for her, and the weight of the allegations that had been presented in evidence before this Commission for her to answer. And then today, she, knowing of the summons, knowing that there had been no response after the request for you, Chair, to stay it, she does not attend. She makes other arrangements, and she effectively took the postponement for herself. Chair, we submit that that is nothing less than a defiance of the summons of this Commission, and that it is time for the law to take its course. Chair, there's an important point that was also made in the judgment to which we will all return with my learned friend, the judgment of the Constitutional Court in January of this year. And it was a point about the equality of treatment of witnesses. Witnesses who have previously sought postponements have done so on affidavit with medical certificates when they have not been able to come, and then there is a cause. The legal team has not opposed those postponement applications. But today we were not favoured even with that, Chair.
Yes, of course, I go back to my first question to Mr. Buthelezi. Do I need to even hear the postponement application when the witness has not complied with the summons and the reason for non-compliance? The reason for a postponement is not the reason for non-compliance, and it's not because is this not like being in contempt of an order of court? You can't be in contempt of an order of court and without purging your contemptuous conduct, ask for other relief from the same court.
Indeed.
You must purge your contemptuous conduct first. You must comply with the order of court, then ask for whatever you are aggrieved about. But you can't defy an order of court and then ask that court for some relief at the same time. You have got to comply and say, I am complying because I know I'm obliged to, but now that I'm here, here is my situation, and I'm asking for this or that relief. So there is that question as well.
Indeed, Chair. The final submission I wish to make is that what happened in Parliament in 2018 should, with respect, not be repeated. There should be a criminal charge laid against Ms. Myeni, and regrettably, for the second time in this Commission's proceedings.
Of course, it's concerning if the National Assembly did not lay a complaint. What the police would have done with it, we don't know.
Chair,
a complaint was laid by the Secretary of the Commission against her some time back. I'm not aware of what progress is being made by the police in regard to it. Maybe there is progress being made, it's just that I've not been informed. Yeah.
Chair, I can update you on that because we were also keen as the investigators to understand what had happened. And we received an update after the most tireless efforts of my investigators sitting behind me, who I think drove around the greater province for the last 3 days trying to track down the relevant investigating officers. The update is that a warning statement was taken from Ms. Myeni last week. And that is where it has gone. There's been a request for an affidavit from me. I'm going to have to deal with that because usually council can't do that. They have received a full report, so we're going to follow it up, Chair. But those are the facts. On the 18th of May, after a complaint was laid in December of last year, a warning statement was taken from Ms. Myeni, according to the account that we received yesterday. And there's a request for an affidavit from me, but we will take that further.
That must be, it was in November.
Yes.
So it took quite some months just to get the warning statement.
Yes, Chair. Chair, if I may, just on one aspect, because I don't want to leave it, and I do have my eye down the line to the recommendations of this Commission. Chair, you signalled to me a moment ago that what is concerning is why Parliament may not have laid that complaint. And I would just like to make one submission on that.
Yes, yeah.
When our team was looking at this, we were concerned about that fact as well. And so we went back to the Powers and Privileges Act. The Powers and Privileges Act makes provision for service of a summons issued by Parliament or one of its committees, as was the case with Ms. Myeni, in one of two ways. It's personal service on the individual concerned, or it's service on a person appearing more than 18 years old at their place of residence. It doesn't include the third alternative of affixing. But sheriffs routinely affix. And interestingly, our Commissions Act, which incorporates the High Court's rules, allows affixing. That's how we successfully served the summons at Ms. Myeni's house earlier this week. But the fact remains that the Powers and Privileges Act of Parliament only allows for those two methods. And so there is a potential for evasion by a witness. It's not clear that the affixing that the sheriff did in respect of that summons from Parliament was in fact a valid method of service under the Act. And so that is what we made of the situation. And it will be a recommendation that we will make to you in due course, that that provision of the Act be amended to add the third alternative, which is an alternative that deals with evasion. The rules of court say it's when the sheriff believes that there are efforts being made not to receive service that affixing is appropriate. And just to close the gap, because if that was ever going to be the justification, that there may have been an error in the service of the summons from Parliament, we should not permit that to happen again. There must be a default position.
of course, I didn't understand, but it's quite some time since I had a look at the documents relating to that matter in Parliament. I didn't understand her to have said she was not aware that a summons had been issued for her to appear before Parliament, because I think that if you are aware of the summons and what it says of its contents, it may well be that the fact that you became aware of the correct information through defective service doesn't avail you, because you are aware, you know your obligations.
Chair, just to be clear, we don't know what the response was, but I did not want to miss the opportunity for this aspect. It's a law point, but it's an important one in my submission, given where we are today. Given that service of summonses by committees of Parliament who are wanting to make people accountable and to summons them as witnesses to appear before them doesn't have this loophole in the future.
No, that's fine.
Chair, those are our submissions.
Thank you.
It's the position of the legal team that the offence has been committed under the Act and that a criminal charge should be laid against Ms. Myeni. If I may hand over to my learned friend if there's anything in reply.
Well, before Mr. Buthelezi come on board, Ms. Myeni was going to deal with two matters, one ESCOM related and the other one's aviation related. I don't know whether Mr. Sleka wishes to say anything in relation to, insofar as this non-appearance affects ESCOM related issues.
Thank you. Good morning, Chair.
Good morning, Mr. Sleka.
Chair, much has been said, and I think I need to emphasize that insofar as ESCOM or Extreme is concerned, a letter was sent to Ms. Myeni last year in 17 October 2020 for her to file an affidavit in relation to two persons who are implicating her, which is Mr. Tsotsi and Mr. Nick Linnell. On the date was given, I think, the 4th of September 2020. Now that's way back, and that didn't happen. We didn't even get the courtesy of a response to that letter, much less an affidavit, Chair. And as I was saying to both my learned friends during the adjournment, there's very little to argue on the postponement, Chair, if the witness has arrogated to herself the postponement. So she's telling us, I'm taking this postponement, decide whatever you want to decide. It's a question of defiance. We don't even get to her request to postpone. She has dirty hands, and she can't ask for relief unless she purged herself of that misconduct, if you like. So, Chair, I couldn't agree more with the sentiment you have expressed. Unless there was incapacitation on affidavit, you would entertain an application duly brought for a postponement. But this is not a proper application for postponement. And I'd agree with my learned friend in regard to what then should be visited upon her in terms of the rules of this commission. And ours is a narrow issue, as the chairperson has pointed out. The issues are very plain. Ms. Myeni could have availed herself and dealt with this matters in less than 2 hours. The Commission is overwhelmed with other work, and we're trying to squeeze her in to finish her evidence. Chair, this is completely unacceptable. Thank you, Chair.
Thank you. And Mr. Buthelezi, somebody must sanitize the podium.
Thank you, Chair. Chair, I have to express my dismay and disappointment at how things have turned out, given what Chair had suggested at the adjournment. And I have to make this point, Chair, because I think it also works towards the integrity of the Commission in itself, Chair. It's disheartening to observe how my learned friends, the evidence leaders, purport or seek to project this commission as a prosecution. Whereas, in the proper understanding of what this commission is about, it's a fact-finding inquiry where witnesses need to account and they need to come assist the commission. On arriving at this commission today, it's now going for 11 o'clock. We've lost 2 hours in engagements between 3 lawyers and
But that's because your client is not here.
Indeed so, Chair.
In defiance of the summons.
Chair, the submission I'm making
And
is
that
the
2
following.
hours is spent trying to establish why she's not here and what should be done about it.
Thank you, Chair. Where I was going to with that point, Chair, about the 2 hours, is that, Chair, I was appreciative of the stance that the Chair had taken that said, if it's not an act of defiance on her part, what pragmatic solution can we arrive at to then solve the problem of getting her evidence on record? And we had departed here with the view of saying, granted, you may not be here, but if your indication is you do want to testify, you've testified online before, it gets us to the point anyone can testify online. Let's find a pragmatic way of implementing that. And since that suggestion, Chair.
Maybe before you proceed, let's start where we should have started. You spoke to her. Tell me what transpired, because from what Ms. Hofmeyer said in terms of what she gathered from the conversation with you,
No, Chair.
it looks like she was on her way to a family meeting, but she undertook to turn back and go back. But
No.
then the story, I want to hear the whole story.
Chair,
What is your response?
that's the objection I raised, Chair.
Yes.
As in to say,
Let's start with that.
yes, I think I was misunderstood by Ms. Hofmeyer.
Yes.
Sorry. When we took the adjournment, I then called her to say, what is your location and what's your availability for this thing to proceed online? She says, I am available. As I'm speaking to you, I should have been on the road to Potchefstroom, but that is not on the plans, and I will drive to the attorneys. So the U-turn story, she said, I'm on standby. And that's why I came back and I said we could be online and proceed within 2 hours. Because she then said, I will have to divert my plans of wanting to go to Potchefstroom later and go straight to the attorneys in Pietermaritzburg. So her availability to me on call to receive directions was informed by the fact I said, I don't know what the DCJ may direct or may not direct. I need you to be on standby so that if there is an amenability to resolving the situation pragmatically, then we can make it happen in the shortest time possible. So it was never an intention not to be available or not to be here. As already submitted, Chair, we came here with the intention to say, due to a breakdown in communication, we seek to find a pragmatic way of making the hearing proceed. And at every turn where we've said we want to make the hearing proceed, we've been blocked. when we said, okay, let's find a way of implementing a solution, the first objection was the fact that the documents will not be there on time. We take the adjournment to rectify that and try find whether we can go online. Now the objection is, no, we must lay a criminal charge. Well, if you lay the criminal charge, Chair, it takes us to this position, then the witness will never come.
Well, the laying of the criminal charge for her non-appearance, I thought I hinted at this earlier, that is one matter.
Yes, Chair.
And that need not stay in the way of her giving her evidence. And if she is allowed to give evidence, that doesn't necessarily mean that a charge should not be laid for the fact that she didn't come here when she was supposed to come, and on the face of it doesn't appear to have had sufficient cause. That may be separate. You know. So from my point of view, the laying of a criminal charge would be one thing. The question whether or not arrangements can and should be made for her evidence to be received today is another issue. The one doesn't need to be a problem for the other. So is her position that in terms of the discussion you had with her, that she is ready to be online and to give her evidence or be asked questions or whatever needs to be done that would have been done if she was here?
Yes, Chair.
Yeah.
That is the position.
And is there an issue about needing some time for her to be read in terms of the bundles, or what is the position?
Well, Chair, we had requested, we'd said at the time when the discussion was held, it was around 10 to 10. And I'd said we'd need between 2 and 2.5 hours for that to be implemented. But we've lost the last entire hour in our own debates, and I think that's why I was lamenting that point, to say we could have been. I accept, Chair, that there's two separate issues. There's the issue of the non-appearance, and then there's the issue of how we then resolve it. Those two are not linked, and we can separate them. And I was wanting to say, look, let's focus on the solution for now. And if the commission feels thereafter that the charge must be laid, then the commission may lay that charge. But we couldn't be consumed in that to the extent that we are, and lose so much valuable time if the intention is on either end to get the commission to progress with its work. And that's the point I'm crying about, Chair, to say, look, it doesn't take the process forward for council to be involved in lengthy exchanges with each other, where the situation exists that says, okay, the witness is not here. Can we get her evidence on record today? If yes, how? Let's move on with the process. Council can come and have the subsequent arguments about what this implies or what this doesn't imply at a later stage. And as to how we must now be drawn into long discussions about what happened in Parliament and doesn't happen in Parliament, it doesn't take the process forward, Chair. And all I've asked for today was to say, let's implement whatever solution that is feasible and practically possible to get her to testify today, as she was scheduled to do.
Okay. Is there anything you wanted to say?
In addition to that, Chair, I also wanted to correct one submission. When I submitted that, I said Ms. Hofmeyer submitted that she was under legal advice to appear. I think that's an incorrect understanding of my statement. I said I took issue with the attorney to say, attorney, please properly advise client about what this means at this point in time. To say that we're only seeing it now still renders us vulnerable. That was a conversation between the attorney and myself, and not a conversation between the client and myself. And the last point, Chair, in as much as past conduct as it relates to Parliament is now being brought in here, Chair, I think it finds no relevance. You, Chair, are aware we were here in November for 3 days, full, and until the end of the hearing, she was here. And there was never at any point, even prior to that hearing, an inclination or a reluctance on her part to appear. So that premise that says she's a person who's prone to want to defy is unfounded, Chair. Not when it comes to this commission. Not when it comes to this commission. And the fact that I'm here, because it gives the Chair the benefits of answers and a perspective. Whereas if there was no legal representative and she was not here on the morning, then, Chair, you can take a view that says there's an outright defiance of the commission. But the fact that I'm here today to make the plea to say, can we pragmatically resolve this and allow the evidence to come on record for the day? And it was my submission to you earlier, Chair, that my client is intent on getting this out the way. So the longer we drag it, it doesn't help either side, Chair. Thank you.
Okay, all right. This is the decision I have reached. One, it's not acceptable that Ms. Myeni did not comply with the summons and presented herself at the hearing this morning. Two, from what I have heard, there appears not to have been any valid reason for her not to appear. Three, the Secretary of the Commission must take steps to lay a criminal complaint with the South African Police Service against her for acting in breach of the Summons and the Commissions Act. 4, I direct that she should make herself available to give evidence today, whether it's via Zoom or any of the methods used for her to appear virtually. So that must happen today. I direct that she should be available. It's now about 11. She should be available from 2 o'clock. In the meantime, I will be able to hear some other evidence to use the time. But she should be available from 2 o'clock. And at that stage, I will indicate what's going to be to happen. But she should be available, and all concerned should be available.
Chair, thank you so much. If I may just raise one aspect.
Yes.
There was the issue of the invocation of the privilege.
Yes.
And there were actually a set of questions in respect of which the legal team was going to seek rulings today.
Yes, yes.
Now, in the interest of time, I'm going to jump ahead
Yeah.
and say that we are going to seek rulings that would require Ms. Myeni to answer those questions if you are persuaded by our
Yes.
submissions
Yes.
on affidavit.
Yes.
So I know we're running out of time today. I'm not going to ask
Yes.
that we do that orally with her, so that
Yes.
effectively at 2:00 we could move straight into the ESCOM evidence.
Yes.
But there is an issue on the question whether those rulings should be made.
Yes.
And I'm just wondering whether we shouldn't get that done now. We've got the submissions from Ms. Myeni's lawyers. And
Yes.
so I and Mr. Buthelezi can address you on them, and then if you're so minded, rulings can be made, or we can do that another day. I just don't want to leave that issue. I know
Yeah.
there's other evidence to
No.
get to, but we could just resolve that now.
I think that I'm inclined to think that the witness ought to confirm whether what the grounds are for invoking the privilege. If she says it is what Mr. Buthelezi has said, then she says so, and then to the extent that argument may be necessary, then there might be a really brief argument as far as I'm concerned, and then I make a ruling. If I make a ruling that the grounds she advances for invoking or justifying the invocation of the privilege are not proper grounds, then I have to instruct her to respond. Now, I can instruct her to respond orally, or as far as I'm concerned, I can instruct her if I deem it appropriate to respond in writing. But I'm inclined to think that she must first embrace the grounds or advance the grounds before I make a ruling whether those grounds are proper or not.
Chair, no, certainly in respect of the evidence that's coming this afternoon.
Yes.
But there's still the matter of the November evidence, in respect of which we went over the transcript. We made the
Yes.
submissions about where the privilege had
Yeah.
been
Yes.
unjustified. The
Yes.
reasons are there. Ms.
Yes.
Myeni gave them each time. They're in the
Yes.
transcript.
Yes.
And then what we shared with our learned friends this week
Yeah.
is literally a list of the questions
Yes.
from that historic
I've
evidence
seen.
in respect of which we were going to seek rulings.
Yeah.
So it wouldn't be a rehash of that evidence. It wouldn't be that she still needs to give reasons. She did give reasons at the time. And to close off that overhanging matter from last time, we were going to seek rulings on those specific questions in her last evidence, where we said the privilege had been incorrectly invoked. I fully understand in the course of this afternoon's evidence, new reasons
Yeah.
may be given.
No, I was talking more about the historical ones,
Right,
not
right.
not the new ones, because obviously with regard to the evidence relating to ESCOM, she has not invoked any privilege.
No,
We
indeed.
don't know if she will
Yes,
invoke
yes.
it. So I was looking at even those, I was saying I'm inclined to think she should be part of the
Indeed.
discussion.
Certainly.
And not just the lawyer, you know.
Absolutely.
But I think that it is something that shouldn't take us long.
Indeed, Chair.
Yeah,
I'm sorry for the misunderstanding on my
Yes.
part.
No,
We
no,
can just
that's
proceed then.
fine. Yes. Okay, no, that's all right. Let me just say, for what it's worth, the witness that I'm going to hear in the meantime is a witness who was going to come in the evening. So I'm just mentioning that, but it may be that we will see how we go. So I think I'm adjourning the hearing of her evidence or our business relating to her to 2:00. and then we'll take it from there.
Thank you, Chair. I understand we might need to make arrangements for the new witness. Should we
Yes.
adjourn for a period
Yes,
for that?
we are going to adjourn. I think the evidence leader in regard to that matter is probably either already here or is listening or watching. So I think that it's now 11:05. I think we should aim to, I'm going to aim to, because I don't know if they're here, aim to resume at, if I don't resume at 11:30, I'll resume at 11:45. I know he probably is watching and listening.
Chair, I've just been informed that we can start from 11:30 from the point of view of the arrangements and the evidence leader getting here.
Okay. Then we'll resume at 11:30.
Thank you, Chair.
We adjourn. morning, Mr. Chairperson. Good morning, everybody.
Good morning, Chairperson. Chairperson, two details before we commence with Mr. Powell's evidence. The first is Mr. Powell is not represented by his attorney here today because he wasn't anticipating to start. I have chatted to him and he's agreed very kindly to proceed in the absence of his attorney, but
Yes.
I thought we should put that on record.
Yes. Okay.
The second issue is that due to an error on the part of the legal team, there are certain annexures to Mr. Powell's statement that were omitted from the bundle. Your registrar has those annexures. It's 15.2 to 15.8. And the place where they will belong in the bundle is after page 424 in bundle 16. So there will be a sequence that starts at 424.1 and commences to 424.19. And if I can ask you...
The ones that she has just handed up are marked 15.2, 15.3, but there are others that are not marked.
I think so 15.2 is a discrete annexure, 15.3 is another discrete annexure. So if there isn't a number on any particular page, it means it's part of the preceding page's annexure.
Okay, there is standard terms and conditions. Is that an annexure to something? Because it's not marked.
Yes, it is. That's part of, I think it's part of annexure 15.5, those standard terms. So it was attached to the, 15.3. So,
oh yeah, 15.3, that's where they appear.
And on they go. I wonder, Chair, if I can ask, possibly I've now paginated my set so they say 1 to 18,
Yeah,
or 1 to
yes.
19.
Yes.
If I could give you this set, then yours will be paginated and I can...
Okay, that's fine.
But could I then have yours back in return?
Okay, thank you. Yes.
Then, Chair, if we can commence and swear Mr. Powell in.
Good morning, Mr. Powell. Thank you for coming back. Please administer the oath of affirmation.
Please state your full names for the record.
Stephen David Powell.
Do you have any objection to taking the prescribed oath?
No objection.
Do you consider the oath binding on your conscience?
I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Mr. Chairperson, I didn't pay attention when you told me where I should slot these. I see the pagination 15.2. Is that what I must follow?
Chair, that's the annexure number. They belong after page 424 of bundle 16. 424.
Okay. Should their pagination be 424.1 onwards?
Indeed,
Shall
Chair.
we do that? So it's 424.1. I don't know whether I want to skip the terms and conditions, but have the right pagination for the next document, which
the one with the 15.4 at the top is 424.8, Chair.
424.8.
And then it will go on all the way through
Yes.
to 424.19.
Yeah. Okay. I'm not going to go all the way, but I think I'll manage as we go along. And then later somebody can just complete that pagination. But
Thank
at
you,
least,
Chair.
I think if you mention a page number that I haven't paginated, I will be able to locate it.
Thank you, Chair.
Okay.
Then, Mr. Powell, before I ask you to confirm the correctness of the affidavit that you've submitted to the Commission, I understand that there are one or two details that need correction. And the first relates to the table of payments from Mr. Mckay to Mr. Cordwell that appears, it's Annexure SP5, it appears at bundle 16, page 293. Can I ask you to go to that bundle, to that page?
Certainly, Chair.
And I
What's
understand...
the page number?
293.
293. Okay.
And I understand that there is a transaction missing from that table. Can you tell the Chair what it is?
Certainly, Chair. There is an additional transaction on 10 July 2015. Chair, apologies, if Chair can note just beneath the table by hand, 10 July 2015, there's a transfer from Mckay to Cordwell in the amount of 35,000 Rand, Chair. And that then will bring the total payments from Mckay to Cordwell from 1,645,000 Rand to 1,680,000 Rand, Chair.
The particular transaction is for how much?
35,000 Rand, Chair, and the date of that transaction is 10 July 2015.
Okay, I've got that. And that you say then with that transaction,
The total goes up to 1,680,000, Chair.
Yes.
Thank you.
Okay, thank you.
And then a consequential change in paragraph 11 of your affidavit where you refer to the original figure of 1,645,000. That's at page 282 of the bundle. 282. And then I presume that figure of 1,645,000 in paragraph 11 must now change also to 1,680,000.
Yes, you confirmed that, Mr. Boyle?
That is correct, Chair.
Yes, okay.
And then I understand also that if one goes to the chronology table at page 281, the second last item reads emails between Shazay, Gordon and Cordwell in relation to ANC T-shirts for which EOH will pay more than 50,000. I understand that requires a correction as well.
Correct, Chair. That 50,000 is wrong. If Chair will please delete that and replace it with 134,200. There were additional T-shirts that we identified subsequently, Chair, that this relates to.
Just
So the
repeat the figure.
50,000 is incorrect on that second last line item on page 281, Chair. If Chair can delete the 50 and replace it with 134,200.
134 or 54?
134,200, Chair.
Okay,
Thank you.
thank you.
Mr. Powell, the technicians tell me that your microphone is a little bit too far away. I wonder if you could move it a bit closer.
Certainly.
Then, Mr. Powell, subject to those corrections that you've made, do you confirm the correctness of the affidavit that appears at page 279 of the bundle?
I do, Chair. This is my affidavit, and I confirm the correctness thereof.
Thank you, Mr. Powell. You have testified before, but I wonder if you can briefly...
Do you want me to accept it as an exhibit?
I do, Chair.
Yes.
Can I just find out the exhibit number? Chair, can you admit it as exhibit VV 2.3? VV 2.3.
Okay. Mr. Stephen David Powell's affidavit that begins at page 279 is admitted as an exhibit and will be marked as exhibit BB 2.3. Okay, you may proceed.
Thank you, Chair. Mr. Powell, you have testified previously. Can you just very briefly remind the Chair who you are and how you came to be introduced to the work of the Commission?
Certainly, Chair. I am the head of forensics at ENS Africa, one of the law firms, Chair. And as I conveyed on the last occasion when I testified on 25 November 2020, I gave evidence relating to an investigation that we had performed at EOH, an ICT company in South Africa, listed ICT company. And I highlighted transactions that we had identified that the Commission asked us to share and provide evidence on. Chair, subsequent to providing that evidence, shortly after completing my testimony, I was asked by the Commission to furnish it with a report into additional items that we had identified relating to some of the witnesses that I had testified about previously on 25 November. The Commission asked us to submit a report specifically into a gentleman or payments that we had identified made in 2015 and 2016 to Mr. Zizi Cordwell at the instance of or by Mr. Mckay, who at the time was an executive of EOH. Chair may recall that previously I testified that there was approximately 400,000 Rand paid from Mr. Mckay's account to Mr. Cordwell, and I gave evidence related to that. What has happened subsequent to that, Chair, is the Commission has subpoenaed bank accounts. During my initial investigation, I only had access to a snapshot of Mr. Mckay's accounts, and the Commission has subpoenaed further accounts of Mr. Cordwell from a relevant financial institution. And based on those accounts, I was asked to review and look at the information and provide a report on additional payments, which we have identified. In addition, Chair, we did some further email analysis because our focus on the previous occasion, Chair will remember, was related to the city of Johannesburg and Mr. Jeffrey Makubo in particular. Mr. Cordwell's evidence that I provided, that was almost collateral information that we just came across and shared with the Commission at the time, We then did a detailed focus of the email servers at EOH to identify if there was further evidence related to the activities of Mr. Mckay and Mr. Cordwell in particular. And we have identified significant transactions, or quite a number of interactions, Chair, I should say, that I will give evidence about today. When I testified earlier, I mentioned that Mr. Mckay was an executive of EOH. It's also important to point out, Chair, that Mckay is a former director of an entity known as Tactical Software Systems Pty Limited. It has an abbreviation TSS, and that company TSS, I understand, is now in voluntary liquidation. Chair, I know I'm saying Chair may recall, and I know Chair has a million things testified before, Chair, but one of the items I highlighted was that EOH Mtombo acquired a TSS subsidiary called TSS Managed Services Pty Limited, now called EOH Africa, by way of a sales of shares agreement between EOH Mtombo and TSS in 2011. The transactions that I'm going to describe to the Commission today, Chair, come out of an entity called TSS, Tactical Software Systems Pty Limited. This is not an EOH company. It remained in the TSS stable. So Mr. Mckay, as you heard, he became an executive of EOH. Prior to that, he was an executive at TSS, and this is an interest that Mckay had in TSS. So, Chair, I just share that so that you don't confuse this with EOH. It's not an EOH company. It's not part of the EOH group. I then submitted a report to the Commission, and that report is attached as SP4 to my affidavit, Chair.
And sorry to interrupt, Mr. Powell, but Chair, the SP4 report appears from page 286. If you can just make a note on Mr. Powell's affidavit. We won't be going to it just yet, but I wanted to give you the reference. Sorry, Mr. Powell, I interrupted you midstream. Thank you. If you'd like to continue.
Perfect. Chair, as I was saying, the Commission conducted its own inquiries and subpoenaed further accounts, and they asked me to review that information, and we have reviewed it. And the email evidence and financial data that we reviewed shows that over the period May 2015 to February 2016, Zizi Cordwell, who I understand was the ANC spokesman at the time, Chair, received direct payments as well as luxury accommodation with a combined value of more than 2 million rand. Chair, last time I testified, we just indicated the 400,000. These are all additional items that we have subsequently found, and this is what I will be covering in my testimony today. What we also discovered was that Mckay and Cordwell regularly exchanged emails regarding what appeared to be ANC donations over this period. A table setting out the direct payments to Cordwell made by or at the instance of Mckay is attached as Annexure SP5. Annexure SP6 is a bundle of extracts from bank statements in support of the transactions. These bank statements are the documents I referred to that the Commission subpoenaed, Chair.
Now, thus far, Mr. Powell, you've been talking primarily about donations to Mr. Cordwell. You speak also of payments to the ANC. Can you say a little of that?
That is correct, Chair. Chair, in addition to the payments to Cordwell, at Mckay's instance, EOH also made payments aggregating to more than 15 million to the ANC or its suppliers. And Chair, I'll just describe for Chair what I'm going to be elaborating on later so that Chair can have a small insight into what the broader landscape will look like. Chair, you will remember when I testified previously about the city of Johannesburg, there were a lot of donation requests instigated by Mr. Jeffrey Makubo, and there was correspondence and communications with Mckay and a Patrick Makubedu regarding ANC donations. And all of those donations were routed through an entity called Mfundi Mobile. Mfundi Mobile was run by a principal by the name of Reno Barry, Chair. Reno Barry also features in these ANC donations. These donations seem to primarily emanate from the Eastern Cape provincial branch of the ANC. And what is interesting, Chair, is that Reno Barry again features as the person administering much of the donations, the management of those donations. And previously, we saw that with the COJ, Mfundi Mobile acted as an intermediary. And what I mean by that, Chair, is EOH didn't donate directly to the ANC. They gave this money to Mfundi Mobile, and it was also around 16 million, Chair, so the numbers are quite similar as well. And Mfundi Mobile then received invoices from the ANC for gatherings, transport, events, printing, T-shirts, etc. In this instance, I will be testifying, Chair, that TSS, the non-EOH entity linked to Mckay, funded a lot of those transactions in the same way that Mfundi acted previously with COJ. And similar to COJ, Chair, Mr. Reno Barry has also kept a spreadsheet reconciling all of these payments that were made on behalf of the ANC. Chair, we will go into each of the specific items, but I thought it would be useful just to give Chair the picture of what we're going to cover.
Yeah, no,
Thank you,
fine.
Mr. Chaskelson. Shall I continue?
If I can just ask you, you've talked about payments to Mr. Cordwell, payments to the ANC at Mr. Cordwell's instance. And in your report, you suggest that these payments appear to be the quid pro quo for support from Mr. Cordwell for EOH's interests in several tenders. Can you just briefly summarize that? Obviously, we'll get into the detail later.
Certainly, Chair. We're going to be going through a lot of communications between Mckay and Cordwell and payments to Cordwell. And you'll see, Chair, we'll refer specifically to the timing of those payments and the activities that the communications relate to. But these seem to have had a direct link or connection to three different procurement processes. There was one at the Department of Home Affairs. There was a tender by the number of 1303/2014, and that was for the provision of Platinum Access Service Solution to government for 5 years. That's abbreviated to DHA Platinum Access Tender, Chair. And then there was another tender to the Eastern Cape Provincial Government Department of Education tender, and that one is referred to as SCUM 6-15/16-0001, and that was an integrated document management and human resources records restoration project. And we refer to that just as the EC Records Restoration Tender. Chair, and the third one is the SASA tender 18/14/ICT for the provision of support and maintenance services of ERP Oracle for 3 years. And that's commonly referred to as the SASA Oracle Support Tender. Chair, I do want to just point out that in respect of the Eastern Cape Provincial Government Department of Education tender, there was an award of 217 million made in respect of that tender to a consortium, and EOH were a 40% shareholder in the consortium. So not all of the 217 went to EOH at the time. Approximately just over 85 million thereabouts would have been their share, Chair. So I just wanted to clarify that particular point.
Thank you, Mr. Powell. What I am now going to ask you to do is to go through, in fact, what I'm now going to do is to take you through the timeline that you have prepared in paragraph 10 of your report. And at various points, I'm going to, when we talk about procurement processes in the context of this timeline, I'm going to ask you just to take us back to which of the three that you have now described the line item refers to. The first line item starts on 13 March, and for that purpose, can I ask you to turn to page 433 of the bundle, 433. And if you can describe to the Chair what the document at 433 is.
Certainly, Chair. Chair, the document at 433 of the bundle is a letter of award from SASA to EOH Matombo Limited. And its header is SASA 18/14/ICT, appointment of service provider for the provision of support and maintenance services of ERP Oracle for a period of 3 years. And this is to inform EOH that they have been awarded this tender. Chair, the tender is worth just over 90 million, but what the document specifies in paragraph 1.1 is that your quoted price of 30,260,160 rand has been accepted for the first year of the provisioning of the above-mentioned services. Second and third year prices will be adjusted based on Consumer Price Index, CPI, as determined by Statistics South Africa. So they only specify the 30, but it will run to just over 90 million, Chair. And Mr. Jaskelson, this is the SASA Oracle tender, so one of the three that we referred to earlier.
Thank you, Mr. Powell. The next item on the bundle has a date 7 April 2015. To explain that item, can I ask you to go to page 484 of the bundle, 484.
Thank you, Chair. It's a bit quicker this time round in my evidence, Chair. We've got a quarter of the volume of documents last time. Chair, this is an email from Mckay, dated 17 April 2015, to Shaze Gordon. Shaze Gordon was Mr. Mckay's professional assistant at the time. She was an employee of EOH. She's no longer employed at EOH. And what this directs her to do is it's an instruction from Mckay to Shaze Gordon, and it reads as follows. Please, can you get me the contract value of both the SASA IMS contract and the SASA AMS contract? I need the value including VAT. Also, can you send me a recon on all travel expenses for our special project with Ingrid?
And were you able to identify who the Ingrid referred to here is?
Chair, we suspect that this appears to be an Ingrid Ndlovu, who was the Parliamentary Liaison Officer at the Department of Social Development. We have found emails which we'll draw to Chair's attention in a moment, reflecting her address as DSD, and that seems to be the Ingrid referred to. There's also reference to another gentleman by the name of Lunga Nkwana that also has links to social development, which we will explain later, Chair.
Now, the item on the timeline has a date 7 April. Can you go to page 485 and explain what you see at 485?
Certainly, Chair. At 485, we've got another email from Shaze Gordon this time to Mckay. The subject is Project Ingrid, and it's dated 18 April 2015, Chair. And it reads as follows. Hi, Gian. Total costs 118 16,908 rand and 54 cents as follows. And then it refers to various entities during April, 7 April to 9 April. And the venues are Premier Hotel Pretoria, and they refer to the first two items are venue hire, 16,425 rand. The second one is 11,125 rand, and it's reason dinner. There's a column specifying reason. And the last one, in respect of 7 April 2015, is City Lodge OR Tambo, and it reflects a price of 13,486 rand and 90 cents, and the reason cited on the document is accommodation, 7 rooms, and then 8 April SAA flights to the value of 8,075 rand and 28 cents, flights, and it's flights to East London. 8 April SAA again, 23,163 rand and 36 cents, Chair. And this is also flights, but this time it's flights to Cape Town. And then the last item on 8 April is Premier Hotel East London, 13,765 rand. And the reason cited on the document is accommodation. 9 April, Wild Coast Sun International, 32,868. Also reflected as accommodation, and the total amount there is 118,908 rand and 54 cents, and the footer reflects Shazay Gordon as executive assistant, Gian Mckay and Zunaid Mayet, EH Matombo.
So that would be and the header of that email is Project Ingrid expenses, is it not?
That is correct, Chair.
The next line item that you have is dated 24 April 2015. And to explain that document, can I ask you to go to it? It's at page 325 of the bundle. It's Annexure 7.2.
Sorry, Chair. Mr. Chaskelson, if I can just interrupt. If we just turn the following page, on the last document, you'll see we're talking about Project Ingrid expenses. And
yes,
if I may, I might just refer to the next email, which seems to also tie up to the same project. It also refers to Project Ingrid, but this time it's an email from Shazay Gordon to Reno B at tssms.co.za, CC'd to Gian Mckay, and it also talks about Project Ingrid, April 2015, ABSA TSS credit card, Gian Mckay. Chair, and if we look at this document, what it shows is Dear Reno. So I presume, Chair, it looks like the Reno Barry that I referred to, the same gentleman that was linked to Mfundi Mobile, here is linked to TSS MS. And what she's writing is, Dear Reno, please allocate the highlighted charges on this card to tactical software systems under Project Ingrid. So in other words, book these expenses, which were incurred by Gian Mckay on his personal credit card, to the project. And then this is a project Gian has started and has run from March 2015 to current. And then she goes on to say, I will be sending you each month's charges. Let me know if I should submit all to you on a spreadsheet and just flag you on the credit card used. And if we look at the breakdown, it's got SAA flights, Chair, 14 April, 30 April, and 131 on Herbert Baker meeting venue, Premier Hotel East London, 16,000 accommodation, and that total is 116,000. Chair, and if you just turn the page, you'll see at FOF 16487.
Where does it? Oh, okay, I see the total. I thought you had left the page that I was looking at. Now I see the total you were talking about. So we go to page 487, you mean?
487, Chair.
Yes, okay.
And what follows there is Mr. Mckay's credit card statement for the period 3 April 2015 to 4 May 2015. And Chair, if you have a look on the right-hand column of the very next page, you will see someone has written in handwriting, Ingrid, halfway down the page, and there's an amount of 192412, and it reflects South African Airways OR Tambo. Chair, have you got that? That is in the middle of page 488.
At 488.
Thanks, Chair.
You say somewhere in the middle.
In the middle, it's highlighted, Chair, and it's got Ingrid on the right-hand column.
Oh, yes, I can see that.
This seems to be one of the personal credit card expenses paid for by Mr. Mckay and claimed back by his secretary, who is now directing Reno Barry to allocate this to Project Ingrid. And Chair, if you turn to the following page, page 489, you will see that there are a further 8 narrations which are highlighted, and they all have Ingrid next door to them, written in. I presume this is Chaze Gordon indicating this on the spreadsheet to Reno Barry, Chair.
Yes.
Chair, and earlier you recall Mr. Chaskelson asked me who Ingrid was. Chair, if you continue this narration and you turn the following page. Sorry,
Mr. Powell, we're still having problems with sound apparently. Can I ask?
I've turned it completely.
Okay.
Thank you.
Thanks.
Apologies, Mr. Chaskelson. Chair, if you turn to the very next page.
Is that 490?
490, Chair. Chair, I mentioned that we identified this Ingrid Ndlovu as a person at DSD. This is an email from Chaze Gordon, dated 5 August 2015, and it's sent to Ingrid N at dsd.gov.za. It also seems to be sent to a private email for the same person, dingindlovu@gmail.com, and then it's copied to Lunga Nkwana@gmail.com, as well as it's CC'd to Gian Mckay. And what the subject header here is, Chair, is TSS Government ANC Women's League 5 to 9 August 2015. And there's an attachment, an EOH Book 1. It seems to be a PDF of a spreadsheet, Chair. And it's marked as importance high. And the narration is from Chaze Gordon. Hi, Ingrid and Lunga. Please see attached final confirmation of hotels and numbers. Total delegates 550. So I think that completes the picture of this particular chain of emails, Chair. Mr. Chaskelson, apologies, I interrupted you.
No, not at all, not at all. If we can go back, I mean, we've seen a series of payments in relation, or emails referring to payments and bookings in relation to Project Ingrid, but I now want to go back to 24 April and to page 325 of the bundle, which, well, can you describe to the Chair what the document you see at 325 is? It's Annexure 7.2, SBS 7.2.
Chair, this is an email from Gian Mckay sent on 24 April 2015 to Zizi Cordwell. Subject, forward, TSS Loan Agreement Template Doc. Attachment, TSS Loan Agreement Template Doc. And it's sent by iPhone, and it forwards a message, and this was forwarded from Chaze Gordon, who'd sent to Gian Mckay this template doc. And then if you go to the preceding email, you'll see that on 22 April at 9:55, Charles Gordon sent to zzcordwa@gmail.com, copied Gian Mckay, TSS loan agreement, to whom it may concern, as requested by Mr. Mckay, please find attached TSS loan agreement. Kindly confirm receipt of this email. Regards, Shazay Gordon and her cell number. Chair, and if you turn the page over to FAF 16326, you'll see this seems to be the template referred to, and it's a loan agreement between Tactical Software Systems Pty Limited with the company registration number referred to as TSS, and the company name is blank. It's to be completed.
Were you able to find any completed loan agreement between TSS and an entity that you could link to Mr. Cordwell?
Not at all, Chair. We looked, we couldn't find any loan agreement that was completed. And this particular template seems to be a misnomer because it refers to an enterprise development loan and the number is blank, rands only blank. And then it talks about company name is a black-owned company. And if you just read the first paragraph of this document, all investments are grounded in the meaningful engagement of the youth, young women, and disabled people in the development of appropriate economic and entrepreneur skills. The primary objective is to create wealth and in that process identify opportunities that will identify youth, women, and disabled by way of creating employment, business opportunities. Company name is managed by a young team for young people with the primary objective of actively participating in the mainstream economy. Chair, this looks like an enterprise development loan, and I would submit, Chair, that I would hardly suspect that Mr. Zizi Cordwell would have been an eligible candidate for enterprise development. I haven't seen anything in the emails and documents that I reviewed to reflect that he was at all engaged in enterprise development for empowerment purposes, Chair. And the reason the document is drafted in this way is because when companies spend on enterprise development, they're entitled to claim that back. They get points for scoring on their BEE scorecard. So this looks like a BEE loan template, but as I indicated to Mr. Chaskelson, Chair, we've never found any signed agreement. We also have analyzed the bank accounts for a number of years, and we haven't found one single indication of a repayment of any loan by Mr. Cordwell from his account back to Mr. Mckay or TSS.
But can I take you to a payment that in fact the Commission found? That is 4 days after this email on 28 April. It's at page 311. And can you describe to the Chair what the document is that you see on page 311?
Certainly, Chair. This is the bank statement. It appears to be a bank statement of Mr. N.G. Cordwell, who I understand is Zizi Cordwell.
And if you go into the credit column, which for the most part is blank, can you describe to the Chair the transaction on the 28th of April 2015?
Certainly, Chair. If you go down about 5 lines, you'll see that there's an iBank payment from Absa Bank, and the narration is TSS. It refers to a settlement, and the value is 1 million rand, Chair. And you'll see the balance was 47,000 rand, and it pushes it up to 1,047,000 rand. Just over that.
Is it the one that has the date of 28 April 2015?
Correct, Chair. It's the only credit amount on the statement, so it's in the column on its own.
A written settlement. Is it the one written settlement or not really?
Correct. It's written settlement, Chair.
Yeah, okay, I see that.
So this seems to be a transfer from TSS of an amount of 1 million to Mr. Cordwell's private bank account.
Then if we go down a week or so to page 314, we are still in Mr. Cordwell's bank statements, but can I ask you to draw the Chair's attention to an item on the 6th of May 2015 on that page? It's page 314.
Certainly. Chair, you will note that this is a further statement of Mr. N.G. Cordwell's bank account. And on the 6th of May, there's a internet immediate payment settlement, ABSA Bank, and the narration there is my car. Chair, and if you move across, you'll see that there's an amount of, on the right, an amount of 890,000 rand. So
Yes, I can see that.
Chair, what this reflects is that shortly after receiving the R1 million from TSS, Mr. Mckay seems to have purchased a car for 890,000.
Yes.
And can I then take you to page 327?
Certainly, Chair.
And can you describe to the Chair what the document that you see there is?
Chair, this is a Standard Bank account of what appears to be Tajari Motors Pty Limited.
And before you go further, did you investigate who Tajari Motors are?
Chair, they're a motor dealership that appears to have been involved in the provision of the motor car for Mr. Cordwell.
If I can take you to your timeline, we're going to be looking at the other side of the 6 May 2015 transaction at 280. On your timeline, you have Cordwell transfers 890,000 from his account to Tajari Motors Pty Limited, trading as Jeep Santon.
That is correct, Chair.
And will you take the Chair to where one sees the receipt by Jeep Santon of this 890,000 rands from Mr. Cordwell?
Chair, we're back on page 327 of the bundle, and you'll see the second line item on this Tajari Motors current account, business current account, is a real-time transfer from ABSA, Mr. N.G. Cordwell, and there it reflects the contra to the entry we spoke about earlier, the 890,000.
Then the next stage of the timeline that I would draw your attention, or that I'd ask you to comment on, is another transaction, this time at page 308.
That is it. On what page?
308, Chair.
308.
And can you tell the Chair what we're looking at 308?
Certainly, Chair. This is another extract of Mr. Cordwell's Platinum Classic bank statement.
And can you describe to the Chair what one sees in the credit column against the date 26 May 2015?
Correct, Chair. 26 May 2015, there's an NPF credit, EFT, and then a reference number with various letters and numbers, Chair, with /J Mckay. So this appears to be a transfer from Gian Mckay to Mr. Cordwell, and it reflects an amount of 80,000. You'll see, Chair, it's the only credit on that account, on this particular page of the statement.
Yes.
Then, although it's not on your timeline, I'd like us to add the transaction that you referred the Chair to at the start of proceedings. And for that purpose, can I ask you to turn to page 298? 298.
Certainly.
And again, can you describe to the Chair what this document at 298 is?
Certainly, Chair. This is another extract of Mr. Zizi Cordwell, N.G. Cordwell's Platinum Classic Bank Statement, and this is for July 2015.
And can you take the Chair to the last entry on that page and describe that entry to the Chair?
Chair, there is an entry on the last line of the page, the last line of the statement, dated 10 July 2015. Immediate transfer credit, First Rand J. Mckay, and it's also referred to as a settlement, and the amount is 35,000 Rand. Chair, and you will recall that we asked Chair to add 35,000 Rand to the total of payments by Mr. Mckay to Mr. Cordwell. This is the 35,000 that we referred to earlier.
Then if we can go literally to the next page, page 299, and it is the same bank statement, but can I ask you to describe to the Chair the transaction on the 13th of July, the credit transaction on the 13th of July?
Chair, these transactions are easy to identify because they usually happen to be the only credit on the statement before you. 13 July, this reflects an NPF credit, and then it has a reference number which ends with a /J Mckay, and the amount is reflected as a credit of 45,000, Chair. So this looks like another transfer of 45,000 by Gian Mckay to Mr. Cordwell.
Can we then go to an event that happened the very next day? And can I ask you to go to page 328 and describe to the Chair what you see there?
Chair, earlier in my introduction to my evidence, I highlighted that we would be zooming in on particular transactions, communications, and dates. And what the evidence leader is highlighting is that straight after this deposit, if we look at the date 14 July 2015, there's an email from Gian Mckay to Zizi Cordwell, and the narration is as follows, Chair. If I may, I'll read into the record. My brother, I hope you're good. If it's possible, please can you ask the Chair to look into DHA RFB 1303/2014. This is the Department of Home Affairs tender that I referred to earlier, Chair. The narration continues. There are games being played. Initially, we were number one. Then Pandalani and the head of procurement decided to reevaluate the bids, and now it seems we are disqualified. The total value is about 360 million. Also, please don't forget to talk to the regional funding coordinator to understand what their funding requirements are. Thanks, my brother. Chair, so this looks like a plea. There's money deposited, and now there's a plea for help. This was a lucrative tender that was going to be awarded. The EOH is now disqualified.
Can I I'm going to possibly take us out of the timeline at this point, just to track what happened in relation to this tender. And for that purpose, can I ask you to go to the very next page in the bundle, page 329.
Certainly, Chair. If you go to 329 in the bundle, you'll see this is from Mckay. It's dated 2 November 2015, and it's sent to Zizi Cordwell, and the subject is Forward DHA, and there's an attachment, a JPG, JPEG, and a PDF document attached.
What do you understand DHA to be an abbreviation for?
Department of Home Affairs, Chair. That's the general
Yes.
description for Home Affairs.
Okay.
Chair, and you'll see later that there is a document regarding this which confirms it is Home Affairs. Mckay had forwarded a document to Zizi Cordwell that he had received earlier that day from a gentleman by the name of Petrus David Janssen, who was an EOH employee, and the date was 2 November 619. So this was all happening quite early in the morning, and it was sent to Sipiwe Nodwele, who was an executive at EOH at the time, and it was copied to Mckay and Janita van der Westhuizen, also at EOH. And Janita says, "Good morning, Sipiwe. Please find attached cancellation letter for RFB 1303. The RFB is a request for submission for a proposal or tender, Chair. And if you turn to the very next page, Chair, 330 in the bundle, you'll see this is a formal letter from the SETA, the State Information Technology Agency, which manages the procurement of these IT projects and services. And it's written to the account manager at EOH, attention Patrick Makubedu. And what it says is, to whom it may concern, cancellation of RFB 1303/2014 for the appointment of 2 separate service providers for the provision of Platinum Access Service Solution for government for a period of 5 years. We regret to inform you that this RFB and the number has been cancelled. SETA would like to thank you for the interest shown in this RFB and regret any inconvenience caused." Chair, so what this means is, if you look at the chronology, there's a payment to Mr. Cordwell, there's a request for his intervention because EOH were disqualified, and now, shortly after, we have cancellation of the tender, and that means that the procurement process would start afresh, and potentially EOH would then be eligible to compete again. They would have lost out.
Can I then ask you, I think we can skip past the spring ball, but can we go to page 281, the top of your timeline on page 281, and the document that appears at page 335 of the bundle, and can you describe to the Chair what that document is?
335.
335.
Thank you. Chair, this is an email from Mckay dated 23 July 2015, also addressed to Zizi Cordwell, and copied on this is lungankwana@gmail.com. And the subject...
That's Lunga Nwana, NCWANA. Okay?
Thank you, Chair. That is correct. And Chair, remember, I referred to Mr. Lunga Nkwana earlier. Nkwana, thank you. Chair, yeah. I did try practice some of these pronunciations.
Right.
And we did some homework just to understand who Lunga Nkwana is. And we found he is linked in adverse media. He was allegedly There were claims in the media that he was used to channel Brett Kebble money to the ANC. He's purported to be a close friend of Duduzile Myeni, the ex-social services minister, and he was implicated in corruption regarding SASA projects previously in the media. Chair, I'm not saying that he was convicted, but there was adverse media. And he was also a friend of Mckay and one of the attendees at his wedding. And there was also adverse media about some luxury accommodation that Mckay had provided for Mr. Nkwana. So I just wanted to mention that name and highlight that the link there, Chair. And if we go back into the email, it attaches invoices, and it looks like there's a number of invoices: invoice 1, invoice 2, invoice 3, invoice 4, invoice PDF, which I presume is invoice 1. And what Mckay is saying in the narration is, my brother, please look at this. People are using ANC letterhead but changing the bank details into individuals or company bank details. Please, can you look into this for me? Thanks, Gian. And what this refers to is a series of invoices that were sent to EOH, and they went through various people within EOH. Chair, and if I can turn you to page 338, these are the documents that the discussion seemed to relate to, and you'll see that there's a number of African National Congress, Nelson Mandela Regional Coordinator's Office, addressed to EOH Matombo, and if we look at the date, it's 29 May 2015, there's an amount of 126,000 Rand, and the bank details are Santaco. Chair, Santaco is the South African National Taxi Association. So this appears to be an invoice for taxi services rather than just an invoice from the ANC. They seem to be claiming for expenses for taxis. And if you look at the next invoice on page 339, it seems to be more of the same. Services rendered, this time 16,800. And this one has bank details of Uncedo Services, Uitenhage. And this seems to be what Mr. Mckay is complaining about. You know, these are purportedly coming from the ANC, National Congress, Nelson Mandela region, but the bank details are all their service providers.
The bank details there, the last one that you mentioned, is Uncedo
Services, Uitenhage.
Uitenhage, yeah.
That's correct, Chair.
Also, these are the letterheads that he was talking about, saying some people are submitting invoices on the letterheads of the ANC.
Correct.
But with different banking details.
Correct, Chair.
Okay.
And the next one is more of the same. The next one is the business zone on page 340. If you go to the bottom of the page, you'll see the banking details. It also says African National Congress, Nelson Mandela region, bank details, the business zone. The next one is another one for Uncedo Services PE, and 28,000 Rand.
And proceeding in this chronology, bearing in mind that the Home Affairs tender hasn't yet been cancelled, we jumped ahead to that. That was November. Can you take the Chair to the very next page, page 342, and describe to the Chair what you see there?
Chair, this is an email on 5 August 2015. And I just emphasize what the evidence leader highlighted, that the tender has not been cancelled. This is sent by Mckay to Zizi Cordwell, subject to sponsorship. And the word in the narration is, my brother, address the letter to EOH Matombo Pty Limited, attention Mckay, Executive Director, and then his email address. If you need a draft letter, let me know, but I'm sure he will be fine with the content. It should simply state that the movement humbly requests assistance in the form of sponsorship of 1 million, in brackets, whatever the purpose, something like that, either from the TG himself or Jerry or any other authority. Chair, I understand TG to mean Treasurer General of the ANC. I'm not certain who the Jerry is, Chair.
And that's an email from
Gian
Mckay
to Cordwell, to Zizi Cordwell.
And he says, my brother addressed the letter to, and then he gives the EOH Ntombo Pty Limited address, attention himself. And then he says what the letter should say. Is that right?
That's correct, Chair.
Okay. But basically, he's asking Mr. Cordwell to either address a letter himself or from TG or from Jerry or any other authority to ask for a sponsorship.
Yeah. He's suggesting ask us to sponsor you.
Yeah.
Can I then take you to...
I'm sure many political parties would like this kind of situation. To be asked to say, please, we've got money to give you, ask us for a donation.
Exactly, Chair.
Whatever the purpose, Chair.
Whatever the purpose.
Can I then ask you to go to page 348?
Certainly, Chair. At page 348 in the bundle, this is a Standard Bank South Africa Customer All Payments Final Audit Report. And you'll see, Chair, that this refers to statement reference, EOH Matombo, account name, the Elections Agency, amount 1 million. So the million that we referred to a moment ago, Chair, it seems to have ended up with a request to pay to the Elections Agency.
And if you go up to page 346, can you describe to the Chair what you see there?
Certainly. Chair, at 346, I'll start with the final email in the thread and then we'll work back, Chair. But at the top of that page, you'll see that there's an email from Gian Mckay, dated 12 August 2015, to Zizi Cordwell, subject, Elections Bank Letter, Confirmation Letter, attachments, and that's got a number ATT 00001 HTM, and then it says POP Election Agency. Chair, the POP is proof of payment. It's the acronym for proof of payment. And then there's an attachment of a PDF. And this was forwarded, Gian Mckay forwarded the proof of payment that he had received earlier that day from Renee Jonker. You'll remember that name from my last testimony. She was a financial manager working with Gian Mckay at EOH at the time. And that followed earlier correspondence where Gian Mckay sent to Shazay Gordon and copied Renee Jonker Elections Bank Letter, Confirmation Letter, and Gian had asked, please send me proof of payment once it's done. And preceding that was communications with Bontle Mpakanyane, Executive Director of the Elections Agency. And Shazay had requested, clearly this was, dear Shazay, herewith bank letter confirming our banking details, kind regards and apologies for the delay.
And that proof of payment of 1 million is what is forwarded by Mckay to Cordwell on the 12th of August at the top email.
That's exactly correct, Chair. So I started with the proof of payment of the 1 million that went to Mr. Mckay, and then we just went through the actions preceding it.
The next item on your timeline is dated 9 September.
I see we are at 1 o'clock, Mr. Chairperson.
Sorry, Chair.
Do you want to do that last one?
It isn't directly related to what we've just been discussing. Wait.
Okay, let's take the lunch adjournment and we'll resume at 2 o'clock.
Thank you, Chair.
Thank you, Chair.